versus Rebecca Allmendinger. The state appears through District Attorney Kevin Schmidt in person. Ms. Allmendinger appears in person.
This isn't your average courtroom. Section. What we're watching is a high-stakes post-conviction motion hearing, meaning someone's challenging a guilty plea from 20 years ago. That's 2 decades of consequences, possibly hinging on whether she even understood her rights back then. This is legal CPR. They're trying to revive justice that may have flatlined in 2005.
Counsel Bruce Anderson. We're set today in this matter for a motion hearing, and that is proceeding as such. Is that correct, Mr. Anderson?
It is.
All right. Mr. Schmidt, are you going to proceed first, or are you going to ask Mr. Anderson? I do not see an officer, so I'm not seeing that we need officer testimony.
No, officers aren't relevant to this, and since it's Attorney Anderson's motion and his burden, I think he'd call the first witness.
All right, Mr. Anderson.
I think I disagree with that. It's my motion, I agree. But once the court grants a motion based on my motion, or grants a hearing rather, based upon my motion and the affidavit, I think the burden shifts.
I think Attorney Anderson's referring to State v. Bangert, which was overturned in 2022 in State v. Clark.
Prosecutor Schmidt whips out State v. Clark like it's a trump card, reminding the court, no transcript. Then the burden of proof stays right where it started on the defense. Translation: this defendant doesn't just need to show something went wrong. She needs to prove it clearly and convincingly. That's a tough hill to climb.
Where the Supreme Court of Wisconsin held that the burden shift only occurs if there's a transcript. If there's no transcript, Bentley applies, meaning the burden is on the defendant to prove by clear and convincing evidence that a manifest injustice occurred.
That is true.
All right.
So, Mr. Anderson, please call your first witness. I'm going to presume Ms. Allmendinger.
Yes.
Ms. Allmendinger, you may come forward, raise your right hand. You're going to be sworn in, and then come have a seat over here at the witness stand.
Do you swear that the testimony you are about to provide in this matter shall be the truth, the whole truth, and nothing but the truth?
Yes.
Rebecca Allmendinger takes a stand. And just like that, we're stepping back in time. Picture this. She's 22, scared, inexperienced, and facing a DUI charge. Today, she's not just recalling facts. She's putting her entire understanding of justice on trial. Her memory might be spotty, but this testimony is a mirror reflecting the system she never really understood.
Please state your name.
Rebecca Joel Allmendinger,
And what is your current address?
2353 260th Avenue, Cushing, Wisconsin, 54006.
What is your date of birth?
September 23rd, 1982.
And you were convicted of an operating while intoxicated in Washington County, Minnesota in 2005. Is that correct?
Yes.
And how old were you when that occurred?
23 years old.
Okay.
Or 22. I was almost
right.
23.
What is your educational background?
I'm a high school graduate.
Any post-high school?
No.
Anytime have you studied law?
No.
Have you ever studied the United States Constitution?
No.
Or anything about the American legal system?
Nope.
Have you studied legal vocabulary?
No.
Now, in this 2005 case in the state of Minnesota, were you represented by a lawyer?
No lawyer, no law education, no clue about her rights, and she's expected to make an informed plea. This wasn't a courtroom. It was a conveyor belt. Justice rolled past her, and she was expected to nod and accept it. That's not justice. That's paperwork disguised as a verdict.
No, it's not.
And when you were found guilty, or any time prior to that, Did the judge personally address you about your rights to having a lawyer?
No.
Did you basically get told by a prosecutor what was going to happen?
Yeah. Yeah, for the most part. Other than talking to some friends that also weren't legal, didn't have a legal background, that said, just get it over with.
Was that your first offense?
Yeah.
Had you ever been involved in any legal proceedings up to that point in your life?
No.
Okay. If you can, if you recall, do you remember how long that court appearance took?
Minutes. It was just
He says the whole thing took minutes in and out, just a guilty plea and done. But the law isn't a drive-through window. It's supposed to be thorough, cautious, and fair. What happened here was rushed, unexamined, and shockingly casual. The legal equivalent of shrugging and stamping guilty.
and that was it.
Okay.
You know,
I believe you might have filled out a form. Do you recall filling out a form?
yeah, I think there was a form that just stated that I understood that I was pleading guilty to the charges.
Of operating while intoxicated?
Yes.
Okay. At any time from the night you got arrested for that case, until you made your final and perhaps only court appearance. Is that your only court appearance?
I believe so, yes.
Were you ever represented by a lawyer?
No, I
Did
never.
you ever even consult with a lawyer?
No, I didn't.
Okay.
I just have to stop you right now. Never mind, you can continue. Sorry, I thought I missed something, but I got it now.
Did the judge in that case ask you questions about what you knew about the law?
No.
Did the judge specifically ask you if you wanted a lawyer?
No.
Did the judge ask you, or tell you rather? Did the judge tell you that if you needed a lawyer for that case, the court could appoint one or would appoint one for you?
No.
Did you know about the fact that you could have demanded a jury trial?
No.
She didn't know she could ask for a jury trial. Didn't know she was presumed innocent. Didn't know the court would give her a lawyer if she couldn't afford one. These aren't just technicalities. These are fundamental rights, and no one explained them to her. That's silence. That's the sound of due process being skipped.
Did you know that you could, that you were presumed innocent? Or did you think you were, based on what you'd seen in the case, did you say, well, I guess I have to plead guilty?
That's how I felt. I knew that I was charged with the DWI because of my blood alcohol level at the time. And I just didn't ever even think it was something you could argue against.
Did the court advise you of what the maximum penalties could have been for that offense?
I don't recall if that was talked about. The prosecutor talked to me ahead of time about what, if I pled guilty, what the penalties, they would charge, but I don't know that I knew what the maximums would be.
So the prosecutor was the one who was giving you advice, basically.
Yeah, for the most part.
Okay. Did you actually know what the prosecution, which in this case was the Forest Lake City Attorney, correct?
Yep.
Did you know what they were going to have to prove to find you guilty?
No.
This prosecutor told you what was going to happen?
Yep.
No further questions.
Mr. Schmidt, questions?
Hi, did you successfully graduate high school? At
Yes.
that time you entered your plea?
Yep.
Did you get held back at all?
No.
You got the diploma?
Yes.
Okay. How'd you do in school?
I did well. I didn't have any, I was A, B student.
AB student. Did you do civics classes in high school back then?
What would civics classes talk about? I did a correspondence homeschooling program throughout 9th or 10th, 11th, and 12th grade.
Oh, were
And
you
it-
homeschooled through high school?
Yeah.
Okay. Did you learn about government operation? Like democracy?
Yeah, the general,
You know,
what democracy is and stuff.
like the separation of powers in the courts and things like that?
I'm sure that was in there.
Okay. Did you ever watch TV or movies when you were that old?
I'm sure I did.
Okay. So when you were 23, you had never heard that people have a right to an attorney.
The prosecutor presses hard. You never heard you had the right to an attorney. But let's be real. This isn't about what she heard on TV. This is about what she understood, raised and never questioned authority. She wasn't equipped to challenge anything. What sounds simple in court, you have the right to an attorney, can feel meaningless if you don't believe.
It was just I had the understanding that the way I was raised, you don't argue against, if you're in trouble for something, you just suck it up. You deal with it. It wasn't a consideration in my mind that I would argue with the police or argue with the court system.
Okay. Let me back it up then. That OWI, you probably were arrested, came into contact with an officer at some point, and that led to the complaint in Minnesota, right?
Yep.
What actually happened? What were the facts of your interaction with the police and why they thought you committed an OWI?
Relevance?
And this is from 20 years ago, where she's literally said she doesn't remember some things in her direct testimony. I'm seeing what she remembers about the incident.
Overruled.
I left a bar and grill. I pulled out of the parking lot onto Highway 61, and I was following a friend, and my friend they went through a light. They didn't go through a red light, but they went through the green light, and then the light turned red, and I slammed on my brakes because I didn't want to go through the red light. And there was a package of light bulbs on my passenger seat that went flying and broke. And when I went to try to stop that, I swerved a little bit. And the cop was behind me, and he saw the swerve, and that's what he pulled me over for.
I noticed you didn't mention anything about alcohol at all. Was
I
there
left
any
a bar,
alcohol?
and yeah, there was alcohol involved. I had been drinking at the bar.
Okay. Was there a blood or breath test?
Yes, there was a
And
breath test.
were you made aware of what the results were prior to you entering a plea?
Objection as to what type of test, whether it was a PBT or a chemical test.
Sustained.
I guess I can get around what I'm asking. Do you think you were intoxicated back then?
Yes.
Okay. So part of the reason you entered a guilty plea is you think you were guilty.
Yes.
Okay. So according to the motion your attorney filed, he's essentially saying that something was wrong with your plea colloquy back then. And if that were the case and that were true, you'd be able to withdraw your plea entirely.
Here's a shacko she never knew she could go back and fight that plea. Never. That's 20 years of living under a legal decision she believed was final. This isn't just a legal error. It's a lost life opportunity. Imagine waking up and realizing a door that's been shut for decades might have never been locked.
I guess, to be perfectly honest, until you just said that right now, I didn't know that I could go back 20 years and do that.
Okay. She just didn't think of it.
It's not that I didn't think of it. I had no idea that that was an option to go back and argue something that I already pled to 20 years ago.
Okay. So I'm going to fast forward then to our questions we're asking about the plea colloquy. If you recall, I went on this detour asking about the actual OWI when you referenced the way I was brought up, you own up to what you did, right? So going back to that question then.
Objection to the characterization of her testimony. She said she was raised not to argue with the government.
She also did say that she was intoxicated and thought she was guilty.
Anyways.
Sustained.
Oh, sustained.
Sorry, overruled in it.
Okay. So I kind of got cut off there. So let me shortcut the question then. Would it be accurate to say then that you did know about the ability to get an attorney, but you just didn't want to because you thought you were guilty and because of your upbringing?
Yes, I would say that's accurate, but also I wasn't aware of what the benefits of having an attorney would have been.
I mean, if you did have an attorney, would you have, given your upbringing, fought the case even though you thought you were guilty?
Well, years later now, from what I understand, had I had an attorney, maybe there would have been different, how do you put? There would have been steps I could have taken to, I guess, lessen the consequences of it. Maybe steps I could have taken to get more help back then, things like that.
Like what help?
Addressing why I was driving and drinking. You know, the types of programs I'm in now, that kind of stuff.
Okay. So you knew you had a right to an attorney. You didn't seek one back then because you felt you were guilty, but also you're saying now with what you know.
She admits it. If she had an attorney, maybe there would have been a different outcome. Not an escape from consequences, but maybe a chance at treatment, a diversion program, a better sentence. The law isn't just about punishment. It's about understanding, growth, and accountability. She didn't need to be railroaded. She needed guidance.
A better idea of what attorneys can provide better than I did back then.
Yeah.
Okay. Do you remember what you thought about what attorneys did back then?
I mean, I knew attorneys. I mean, I knew that an attorney would, like, I don't know, quote unquote, fight for you, or, you know, obviously the attorneys understand the laws and how the court system works. You know, all that all works together.
Okay. So back then, did you know that there was a presumption of innocence, as that term is sometimes used?
I'm sure I had heard plenty of times innocent until proven guilty. But in my mind, back then, the until proven guilty was, you know, the breathalyzer that night.
Because the breathalyzer result was one of the things that made you think you were guilty.
Yep.
Okay. And did you know that you had the right to testify or call witnesses if you did have a trial? Like you could put on your own
defense? I guess I can't answer that honestly. Back then, I don't know if I would have ever realized that a DWI goes to a jury trial. Like, Honestly, I thought it was just something that was between the prosecutor, the defendant, and the judge. I didn't even realize that that was again, like I said, I naive about the system.
Did you get jail back then?
No.
Were you told it was possible to get jail?
Yes.
Were you told it was possible to get jail if you didn't accept a plea bargain?
Yes.
And that was part of your consideration as to why you entered the plea bargain?
Yes.
Okay. Gonna show you a document.
Yeah, okay. Yeah.
I'm gonna show you this document, let you handle it, and I'm gonna ask you about it. Do you recognize that document?
I mean, I can read it and know what it is. I'm not going to say that, yeah, I remember seeing this, but
What is
I'm
it?
sure it says it's an affidavit in support of motion to exclude evidence of prior convictions from sentencing.
Is that the motion Attorney Anderson originally submitted on March 13th? The unsigned one?
It's not the motion.
I'm sorry, the affidavit.
Thank you.
Yeah.
And he had shown that to you before he filed it?
Is this the one, Bruce, is this the one that,
You can't ask him questions.
oh,
Just
But,
yeah.
answer.
Your Honor, I'm
yeah.
going to object to the unsigned one because I believe the filed document was filed on March 18th, included corrections and additional and different statements, things that were crossed out and so on.
It was definitely amended. Where are you going with this?
This is a filed document. This is document 26 in the case.
I do have that document pulled up. I'm going to overrule to the extent that I'm going to provide instruction that just answer what you know. You don't know, you don't know.
okay.
Judge, could she be provided with a copy of the other file?
I will be providing that later. This is my questioning, not Attorney Anderson's.
She will,
Well,
I will make sure that she has copies of both. And I believe the question was simply, did you review this prior to it being filed?
Yes, this unsigned one before the edits.
I don't know.
I don't know what the relevance of unsigned document is.
You filed it.
I did that.
I'm going to take it for what it is. She answered, she's unsure.
Okay, so you're not sure if you've reviewed that document. I'm going to hand you another document now. I want you to hang on to that one up there. You recognize that one?
Yes.
What is that?
This is the one I signed.
Why does the signed one have all those pencil edits and the unsigned one does not?
I don't know.
Did you know that Attorney Anderson had filed that unsigned one?
I knew that he wanted to get one filed.
Okay. I'm going to show you. Let me ask you this. The hearing where you had the plea colloquy with the judge way back in the early 2000s on the OWI, who was the judge?
Objection assumes a fact, not an evidence.
I don't know.
What is the fact, not evidence?
You can, if there's an objection, Ms. Allmendinger, just wait until I give a response as to whether or not you have to answer. I understand you're nervous right now, but you objected facts not into evidence, and your question was what facts are not into evidence?
She's not testified that there was an actual plea colloquy. In fact, I believe she said there wasn't what's known as a colloquy. I didn't use that exact word, but the question said at the time she had the plea colloquy.
I'm going to sustain, and just on the basis, I'm going to guess foundation.
You had said when you were in direct examination with your attorney, you were in front of the judge at some point for the plea and sentencing for the OWI, correct?
I believe so.
You don't remember?
And for the record, I'm just going to say this was from Minnesota, so it is a DWI in Minnesota, but in Wisconsin, they are OWIs. And so Mr. Schmidt is kind of interchanging them simply because Wisconsin uses OWI, not DWI. So you can just infer them as the same.
Okay.
Okay.
Do you remember seeing a judge at all?
I believe that I think I did see a judge after talking to the prosecuting attorney.
But do you have any memory of the interaction with the judge?
I have a memory of standing at a podium and the judge asking what I pled, or I guess I'm assuming it was the judge asking what I pled, and I pled guilty, and then prosecutor agreed to it.
You say you assume it was the judge. Why are you only assuming it's a judge?
Well, because I was in a courtroom and there was the person sitting kind of like this, and
For the record, Ms. Allmendinger has pointed to the court's bench.
Were they in robes?
I would imagine you're asking me a bunch of details about that long ago. I mean, yes, I would say it was a judge.
Okay. Do you remember anything the judge said?
Like I just said, he asked what I pled, and I pled guilty. And then he asked the prosecutor if that was acceptable. I believe the prosecutor said something about accepting it, that we had worked out a plea.
Is the only thing he asked you how you pled?
Yes.
He didn't ask any other questions the whole time?
Yes.
Did he say what your sentence was?
By the end of it, she doesn't even remember the judge's name or the prosecutor's. That courtroom experience was so disconnected, so impersonal that the people in power left no impression at all. This wasn't justice served, it was justice skipped. A deal was made, a life moved on, and no one bothered to check if she actually knew what she was signing up for.
I believe the prosecutor is the one that told me that.
The judge didn't pronounce any sentence. The prosecutor said what it was.
You can take your time and think about it.
The prosecutor did tell the judge what we had agreed on, and then the judge repeated it back.
Okay. But you don't remember who the judge was?
No.
Do you remember who the prosecutor was?
No.
Okay. So jumping ahead now, at some point you attempted to get documents to help you at this hearing at the Minnesota courthouse, like more recently, correct?
Mm-hmm.
How did that go?